going about this. Has the time come to reevaluate the structure and scope of reservations, not to weaken affirmative action, but to ensure it remains fair and relevant?
I have a slightly different take on reservations, which was your question. Reservations were introduced in India in the backdrop of centuries of discrimination against the marginalized groups in our society, who did not, by the way, constitute a minority, but constitute the majority of the country. That's the difference, say, between India and the US. Now, the idea, therefore, was through reservations and affirmative action to mainstream them into Indian public life, in Indian social life. The Constitution itself was not just an instrument for the transfer of political power from a colonial to an independent Indian regime, but an instrument of social transformation. So there were two parallel movements which were going on when the Constitution was drafted. And reservations in that sense proceed on the postulate that you can have a stable polity, you can have a stable society when all elements of the society, including those who have been historically discriminated against for centuries, are brought into the mainstream of discourse. Now, we have to ask ourselves this question. Can we say today, 75 years after the Constitution has been adopted, that discrimination against, say, the marginalized communities, the scheduled castes, the scheduled tribes in particular, has ended after 75 years? And the answer to that would be clearly in the negative. You still have students who commit suicide, Dalit students who have committed suicide in the IITs or in different institutions. So which means that the time where you can say that discrimination against the scheduled castes has ended has still not arrived in India. India still faces that. Having said that, judicially, there has been a number of very innovative approaches to reservation. One of the decisions which we rendered as part of the Constitution bench was on this issue of subclassification. Can a state government subclassify the scheduled castes which are notified by Parliament or the President, as the case may be, so as to confine or give benefits to the most backward amongst them? The Supreme Court said yes. There's nothing in the Constitution which would prevent a state government from identifying those castes which are truly backward and then ensuring that benefits go to them, so that the benefits are not really absorbed by the most forward amongst the backward communities. So we've permitted that. The other reservation in India is for the socially and educationally backward classes of citizens, the OBCs as we call them. That's how the Constitution calls them. Now, we've applied the creamy layer doctrine to reservations for the socially and educationally backward classes of citizens, which means that the most affluent amongst the socially and educationally backward classes of citizens are excluded from the benefit of reservations. The final point which I want to make on this, of course, you can spend the whole afternoon discussing this, is on what do you really mean by merit? Does merit mean, for instance, the scores which you clock on the NET, National Eligibility Exam Entrance Test for medical admissions?